Good morning, everyone. My name is Ronald Talasasa, and I am acting on behalf of the chair of the Pilon Corruption Working Group in the Republic of Nauru. It is my pleasure to welcome you to the first of the three-part webinar series on whistleblower protections. This series has been produced in partnership between the Pilon Corruption Working Group and the United Nations Pacific Regional Anti-Corruption Project. It is crucial to discuss and explore whistleblower protections in the context of corruption because of the clear links between a strong whistleblower framework and a reduction in corruption. In addition to this series of webinars, the Pilon Corruption Working Group will also be producing a series of animated videos on whistleblower protections for the Pacific later this year. The speaker in the webinars is Dr. Ashley Savage, a consultant for UN-PRAC, which is a joint UN Office on Drugs and Crime and UN Development Program Initiative. For UN-PRAC, Dr. Savage has produced an analysis on whistleblower protection in the Pacific, which forms the basis of these three webinars. Dr. Savage holds a PhD on unauthorized disclosures and whistleblowing and specializes in good governance with a focus on whistleblowing as a tool in the fight against corruption. Dr. Savage has previously provided training and consultancy services to UNODC, the Council of Europe, and the European Union Anti-Corruption Initiative. He has worked for the University of Liverpool and Northumbria University and written a number of publications on whistleblowing. In this first webinar, Dr. Savage discusses who should be protected by a whistleblower framework, what types of information should be protected, ways that the whistleblower report could be made, and provides an overview of risks to the whistleblower. On behalf of the Pilon Corruption Working Group, I would like to thank Dr. Savage and specifically UN-PRAC for establishing this important partnership with Pilon for the benefit not only of the Pilon members, but also the broader Pacific community and its people. I hope that you enjoy watching it and that you will join us for the second and third webinars in the series, which will be released in the coming months. Thank you.
Whistleblowers are often the first to witness wrongdoing or malpractice in organizations. They can play a vital role in the prevention and detection of corruption and other forms of misconduct, which could cause harm to the public interest. By establishing effective reporting systems, and by providing legal protection to those who report, countries and organizations can provide a safe and supportive environment for whistleblowers. Public and private organizations who adopt internal policies and procedures will benefit from the opportunity to respond to reports without delay, preventing major scandals or the risk of severe reputational damage. Anti-corruption and law enforcement agencies can benefit too. Agencies cannot detect every criminal offence, and research has shown that information provided by individuals is one of the strongest ways in which fraud, corruption, and other forms of wrongdoing are identified. So the purpose of this webcast is to provide you with an introduction to the topic of whistleblowing. And we're going to look particularly at how countries might develop a comprehensive whistleblower protection scheme. We're going to have a look at the concepts, identifying and defining important terminology, We're going to work out who should be protected and what types of wrongdoing and malpractice may be reported. And we're going to consider the various routes to reporting as well. And at various points in the webinar, we're going to consider sources of good practice and examples from different countries. So let's start with the terminology by asking the question, what is a whistleblower? Many of you will obviously be familiar with the term due to your working practices, or perhaps due to reports about whistleblowing in the media. Now, despite the term being widely used, there isn't a universally accepted definition. Different countries can use different definitions of whistleblowing, and different organizations too. Some organizations and countries use the term whistleblower, and some use the term reporting persons or refer to public interest disclosures. There's all sorts of different terms being used. For example, in Papua New Guinea and the Solomon Islands, their laws expressly use the term whistleblowing, whereas in places like the United Kingdom and Australia, their laws use the term public interest disclosures. And Article 33 of UNCAC uses the term reporting persons. Now, there can be lots of reasons why a country might choose to adopt a different term to whistleblowing. And it could be that it's due to the local language that's used in a particular country, or as Pylon identified in its guidance in 2011, in cultures where whistleblowing has a disapproving implication, a different term may be preferred. Whatever term is chosen by a country, the most important thing is that it's very well defined and it's used consistently across the country and across organizations. Because workers looking to raise concerns or make reports need to know where they can make those reports, how they can make those reports, and whether they will be protected if they do so. So now I want us to consider who might be a whistleblower. Whistleblowers are most widely considered to be organization members. They may have insider knowledge, hopefully they should have insider knowledge of the wrongdoing or malpractice that's going on in their organizations. They also face particular risks because they could suffer detrimental treatment in the workplace or be dismissed. Aside from having their identity protected, a whistleblower needs to have protection from detrimental treatment or dismissal and other measures to support them to keep working in their organization. And it might be that a whistleblower might need witness protection. But a witness protection law on its own and a witness protection scheme is not a replacement for a comprehensive whistleblowing law. Whistleblowers who make reports will not necessarily become witnesses in criminal or civil proceedings. Ideally, the information reported by whistleblowers should be used by organizations and by authorities as intelligence to conduct further inquiries. And these inquiries will then uncover evidence which might then lead to criminal proceedings if required. Now, in these circumstances, the whistleblower would not need to participate as a witness in any eventual trial. However, it's recognized that there might be times when a whistleblower might need to be attending court as a witness. For example, because of the rules of criminal procedure, or because of the nature of the evidence which is being presented before the court. And in those circumstances, measures should be taken to protect the identity of the whistleblower as the source of the information. We have already identified that whistleblowers or reporting persons are individuals who are organization members. So in that case, it's good practice to include the following persons in the scope of protection. And you will find these persons mentioned time and time again in a lot of the best practice guides that are available, which are published by numerous different organizations. So we would want to protect full-time and part-time workers and employees. We would want to protect trainees, interns, individual contractors and consultants, and all of these individuals could be working in both the public and also the private sector. So we would want to cover both the public and private sector in our whistleblower protection law. Now, the country may also wish to consider including volunteers and also job applicants who may observe wrongdoing or malpractice during the recruitment process. And we are now slowly starting to see whistleblower protection laws, which are also starting to extend to colleagues of the individual whistleblower who might be caught up in the process and might also suffer detrimental treatment, and also potentially family members who might work at the organization or they might not, who also might be retaliated against. So these are also individuals which we might want to protect as well. And you know, it's good practice to at least consider protecting these additional persons. Some jurisdictions have sought to extend the whistleblower protection even further to cover all citizens in a country who could report any kind of issue. The challenge with this approach is that whistleblower protection generally recognizes the specific vulnerabilities faced by workers who report concerns and provides measures to protect workers and provides different forms of redress for those people. Therefore, it's not meant as a general freedom of expression law to cover all citizens. That's not the purpose of whistleblower protection. And if we apply whistleblower protection to every citizen in the land, it kind of waters down the meaning behind the protection. And it may be more appropriate instead to adopt different laws, and different measures to apply for people who aren't whistleblowers. So members of the public who make particular complaints, service users, patients in hospitals, people like that, they might need different protection because they have different issues and might encounter different risks to individuals who are specifically working in organizations. Now I'd like to look at the types of information which should be protected. And Pylon advises that Pacific Island countries should provide the widest possible definition. And I agree with that. And I think probably the majority, if not all, of the best practice guidance at the moment also recommends the widest possible definition of information that can be protected under the whistleblower protection law. So countries should allow reports about criminal offences, breaches of legal obligations, including but not limited to environmental and leadership codes. And Pylon further recommends states consider including maladministration, misconduct, and misfeasance in the definition as well. Now, you should note that these types of wrongdoing go much further than corruption offences, and it's now increasingly being seen as good practice to provide a very wide definition which extends beyond corruption. So we've seen what types of information should be covered as part of the definition. Let's consider what might not be covered as part of the definition. So personal employment grievances would not normally be covered. So if I were to make a complaint about a manager for not promoting me in the workplace, that would be something that would normally be seen to be a personal employment grievance. But there are circumstances where a personal grievance could uncover a serious public interest issue. For example, serious bullying, sexual harassment, or matters which could impact on the safety of staff or citizens. These types of reports are likely to be relevant to the public interest rather than to the private interests of workers. So to give you another example, or examples, a report about the sustained culture of bullying in an organization can be contrasted to a complaint about someone not receiving their correct holiday leave entitlement. Clearly, these are two very, very different issues. Before we now proceed to consider how the reports may be raised, I would like to highlight that it is common for states to attach conditions on the way that the disclosure was made, and this is in order for people to qualify for the protection. Article 33 of UNCAC, for example, identifies that protection should be provided for those who report in good faith and on reasonable grounds. Pylon recommends that a good faith test should be included to prevent abuse of the whistleblowing law. It is important that if included in the law, the good faith test should be linked to the information contained in the report and not to the motive of the person making the report or making the disclosure. And this can be because a whistleblower could be retaliated against because the organization could challenge the person's motivation for making the report. And then what ends up happening is that the message becomes about the whistleblower and not about the whistleblowing concern. And we want to avoid that at all costs. Countries can minimize the risk of any confusion from taking place by providing a clear definition in the law. And further guidance on these points can be found in the UNODC's resource guide on good practices in the protection of reporting persons. So far, we have considered the definition of who might be a whistleblower and what information should be protected. We are now going to look at how concerns may be raised, and there are three main ways that whistleblowers can raise their concerns. The first is by making internal reports within organizations. The second is by making reports to an external authority, such as an anti-corruption agency, law enforcement, or to a regulator. The third is by making reports to the media as a journalistic source or direct to the public, and this could be perhaps by using social media or a blog to bring attention to whatever issue the person wants to raise. Let's start now by considering internal reports. It is good practice for whistleblower protection laws to be drafted in a way which encourages workers to make internal reports. Research from the UK and elsewhere has found that whistleblowers will often try and report their concern internally first before going outside of their organisation. At a minimum, whistleblower protection laws should provide protection for concerns which are raised internally to organisations. And organisations should provide a whistleblowing policy and procedures which clearly set out how workers can raise concerns, and also they should set out how the organisation will deal with the concern once it's been received. An example of this is in the Cook Islands, where the Ministry of Finance and Economic Management has published a whistleblower procedure which details how to raise fraud and corruption concerns and provides the contact details of where to make the report. Now, workers should be allowed to choose from a range of different options to make their reports. It should be possible to make a report to all persons within the management hierarchy. And this is because sometimes whistleblowers may feel more comfortable speaking to one trusted manager over another. And sometimes certain managers could actually be involved in the wrongdoing as well. So it's important that the whistleblower isn't restricted from only going to one person, for example, the head of the organization. It is good practice to appoint a person outside of the management hierarchy as well who can receive the reports. Now, depending on the size of the organization and the feasibility, an independent unit could be established to receive the reports. So this is a specific independent unit with responsibility for handling the whistleblowing concerns. And an internal control department or a compliance department could also carry out that function as well. Now, it's important to recognize that people prefer to communicate in different ways. Some people might like to use the telephone, others might only like to communicate via text message or by sending an email. And some might want to go in person to speak to someone directly. So it's really, really important that organizations provide a different range of ways that people can report their concerns. And really the rule on this is that the easier it is for people to make the reports, the more chance people are actually going to make them. Just to highlight this as well, because this is something now that's increasingly happening, which is that some organizations choose to outsource their whistleblowing function to an external service provider. For example, in Barbados, Crime Stoppers Barbados operates an integrity line. And this integrity line is independent from their own Crime Stoppers program. The integrity line that they have specifically allows workers in organizations to report concerns anonymously and confidentially. And now we're starting to see commercial organizations as well, increasingly offering these kinds of services where they would offer a hotline, a whistleblowing hotline or something similar to that. So these are options, but it's extremely important whether this resource is being provided by an external service provider or whether it's being provided internally by the organization. We must make sure that the people receiving the whistleblowing concerns are adequately trained to handle those concerns and to protect and support the whistleblower. It's also extremely important that there are clear processes in place to assess the information and to conduct investigations. Organizations should therefore develop protocols, and these protocols should be there to allow the proper investigation of the concerns. And it is good practice to appoint an independent investigator who is not linked to either the reporting person or the wrongdoer. So we need to have someone independent so that proper investigations can take place. This is just an introduction at this stage, of course, and I will be providing more detail on many of these points raised when we work through the materials in the other webinars. Now, we've looked at internal reporting, but what happens if someone wants to go outside of the organization externally to an authority, so an anti-corruption agency or a law enforcement agency or the police? Well, there are two main possibilities, at least that I can think of, in the law, in a whistleblowing law. This would either be to allow external reporting to authorities directly, where they would not need to exhaust any internal procedures first. They wouldn't have to go through their internal procedures first. The second option would be that they have to go through the internal procedures first and raise their concern using those internal procedures before they are permitted to go externally to an agency. Now, the problem with the second possibility is that it's going to create issues down the line. And that is because it places so much reliance on the internal mechanisms within the organizations to work effectively. If you can imagine, if you have an organization that has a poor response to whistleblowers and a poor set of procedures and a limited policy, then what you will end up having is whistleblowers who will struggle to raise their concern internally, but they have to raise their concern internally in order to then go to an authority. So we have to ask ourselves, wouldn't it just be better if we allow those persons to just raise their concern straight to the external authority without having to go inside? Now, the way that this can kind of be worked out in the law is that you could apply conditions, legal conditions, for persons who go outside of the organization. Now, you would not want to make those too stringent and too strict, because we don't want to restrict people from making concerns. But for example, in the United Kingdom, what happens is that disclosures to a prescribed person, to a regulator, would need to meet a higher legal threshold than for the concerns that are just raised internally. So it's almost like a stepped or a layered approach, which has more conditions attached to it, depending on whether you raise the concern internally, externally to a prescribed person, or straight to the media. So this is just something to consider at this stage. And obviously, countries would need to do more research and really think these things through prior to trying to enact a law on this. Now, in terms of thinking which authorities you could allow whistleblowers to raise concerns to, of course, this is going to be a matter for the country to consider. But what I would say is I think there are potentially two suggested options to make this happen. The first way of doing it is that the country could establish a dedicated whistleblower agency or authority. The second way would be that they could task existing agencies to receive the concerns, to receive the whistleblowing reports. I would probably advise countries to establish reporting channels using existing authorities and agencies. I believe that this will be easier because there will already be several laws and procedures in place governing the conduct of those authorities. And the staff there should already have at least some degree of experience and expertise in investigating certain types of wrongdoing. So it provides a starting point with which to build a whistleblowing department or whistleblowing procedures for persons within the agency to follow to respond to whistleblowing concerns. And the other thing to consider as well here is that by allowing whistleblowing disclosures to several different authorities and agencies with different competencies on different subjects and areas, this will ensure that the whistleblower can raise a concern to the agency with the expertise to actually investigate and deal with the issue. So they have the competency to deal with the particular issues. In the United Kingdom and the Republic of Ireland, they use a system of what's called prescribed persons. So this is where agencies or regulators or persons with some kind of regulatory competence are prescribed to receive the concerns. In Jamaica, they use a kind of a hybrid system where disclosures are allowed to prescribed persons, and they provide a schedule in the law which prescribes a number of different places where people can raise the concerns to. But they also allow disclosures to be made, reports to be made to an authority which is designated with monitoring compliance under the law. So those are kind of two different ways of doing it. What is important is that authorities and agencies are tasked with receiving the concerns, and then those authorities need to make sure that they've got a formal policy and procedures in place which outlines what their role is and what their responsibilities are to deal with the concerns and to protect the whistleblowers. All of this, of course, needs to be backed with training for all of the persons in that organization who might receive concerns from whistleblowers, and also the investigators of those concerns as well. And it's good practice for agencies to specify appropriate timescales for conducting an initial assessment and investigating the whistleblowing concern. And this is all about managing a person's expectations. So by managing the whistleblower's expectations, by telling them timescales where they can expect to hear from the agency, you can actually manage the expectations of that person and kind of reduce their fears a little bit. They still might be nervous, of course, because this is quite a serious thing that we're dealing with, but it helps to kind of put them at ease a little bit. It also ensures a degree of trust in the agency, because there are clear timeframes in place, there are clear policies and procedures in place that everybody is going to be aware of and know. And so we would expect, for example, that the investigation, if an investigation happens, that it concludes within a particular time frame, that we're not waiting for perhaps 2 months or 2 years, but we might be waiting, for example, 3 months or 6 months, whatever the appropriate timescale is that the agencies or perhaps the law would set. Okay, so it's a good idea for authorities to outline what information they can receive from whistleblowers, what they can investigate, and what sorts of information they require to assess the report. And the agency could provide this as a sort of a checklist for the whistleblower to consider. Now, I would say this is a good idea because whistleblowers aren't going to know what information they should be providing. They might obviously know about the concern that they want to raise, but they might not have thought through all of the particular details that the authority, the agency, wants to know. So by providing a checklist, you not only make it easier for the whistleblower, you also make it easier for the agency, because the agency is going to be provided with more information that they can then make a thorough assessment of without them needing to go backwards and forwards with the whistleblower. This is also particularly important where the whistleblower has chosen to raise the concern anonymously, and the agency doesn't have the opportunity to go back to the whistleblower to get further information. So what I would like to do now is just to briefly give you some suggestions of the type of information which might be useful to agencies. And this could be at least part of the checklist that the agency might want to provide. So the first thing will be the time and date of any alleged incidents where the wrongdoing has taken place, whether other people witnessed the incident or incidents, who those individuals are. You may also want to know further details of where they were stood or located at the time, whether they had a clear view. All of these evidential matters that we would want to do. So we could develop a clear evidential picture which is going to help us. where the incident took place, what time of day it was, where it was, all of these kind of factors. And the wrong, what is the harm to the public interest that they are trying to stop? And this is something that I advise when I do my training and consultancy work. This is the most important thing, because a whistleblower sometimes can be so caught up in the moment and the stress of the situation that it makes it difficult for them to actually articulate what the issue is that they are raising. And we want to know, in particular, what is the risk, what is the harm that has been caused or will be caused by the person who is alleged of committing this wrongdoing. So by asking this question, it's a really, really good thing to help us to get the whistleblower to think about this. And it allows the agencies to make a more accurate assessment of what the problems are. The last thing on this as well, and of course there might be other things you want to add to the checklist, these are just ideas, but it's whether the person has tried to raise the issue before and to whom. And this is useful for a couple of reasons, because we want to know, has the person raised the concern internally? Have they attempted to address it internally? Is this not a whistleblowing concern at all? Was it not taken seriously, and it should have been taken seriously? So it helps us to develop that kind of picture. But also, this is important because we want to know if the whistleblower has raised their concern internally and then they decide to go to an authority, it's going to be potentially quite obvious when the whistleblower has raised that concern to the authority, and then the authority starts investigating the organization. So it could end up creating extra risk or potential harm to the whistleblower. So we need to be extra careful. So we want to know these things. As an additional thing to consider as well is for the agency to receive information about the whistleblower's employment position so that they can conduct a risk assessment and assess the particular risks to the whistleblower. And so when I say their employment position, I might want to know things like, for example, have they ever been subject to disciplinary action before? Have they got a bad relationship with any managers? Have they been accused of anything in the past, or have they been accused of anything, in the present time, recently? Now, I must stress that these things are not so that the agency can question the motive of the whistleblower. I've already said before that if we consider good faith in a good faith test in a whistleblowing protection law, the motivation is not to challenge the whistleblower, to challenge the conduct of the whistleblower in raising the concern. It's not about that. It's this here, what I'm talking to you about now, is about us assessing the potential risks to the whistleblower. Because if the whistleblower has a bad history with a particular manager, and then they raise a concern about that manager, it could be that the manager suspects the one person in his or her department that doesn't like them or that has a bad history with them. And that could, again, increase the risk of that person being identified. So this is not about us saying that then that person can't be protected. It's about the agency having to take additional steps, additional measures to protect the individuals. And we will talk about this in more detail in the next webinar. Some agencies and also countries, of course, who will be implementing the laws will need to determine whether or not they are going to accept anonymous whistleblowing concerns. So it's obviously going to be a very, very necessary for organizations to do this. And I just want to highlight that it's increasingly been seen now as good practice to allow anonymous reporting, because it is recognized that whistleblowers can take very, very grave risks in coming forward. And so, this might be the reason why they want to raise a concern anonymously. And we're going to consider this in more detail in the next webinar, which specifically deals with whistleblower protection. Now, provided that there are sufficient protections in the law, reports to authorities should provide a safe way for whistleblowers to get their concerns addressed. Because the report is being made outside of the organization, it could be that the organization will attempt to retaliate against the whistleblower, particularly if they disclose confidential documents. It should therefore be legally permitted to disclose documents or other forms of information to the designated agencies. And this may require amendments to existing laws governing confidentiality. Or it might be that the whistleblowing law could provide immunity from criminal or civil action when that person is making the report. So if they potentially breach a law by making a report, then they would be protected under the law from doing so. They'd be protected from any legal repercussions for doing so. In addition to all of these things I've just discussed, it's important that authorities adopt all necessary measures to protect the whistleblower's identity, not just when the concern has been received by the agency, but at all points during the investigatory process which may follow and beyond. Finally, in this part of the webinar, I would like to focus on public reporting. Now, many countries allow reports to the media or to the public, and these can be risky for the whistleblower because the information contained in the report could be confidential, or it could cause harm to the privacy rights or data protection rights of others. So consider, for example, a scenario of where a whistleblower decides to raise a concern. They work in a hospital and they believe that there is some form of corruption going on, which involves patient data in the hospital. So what they do is they disclose a document containing all of the confidential data of those patients. Well, it could be that that data does prove some form of corrupt activity or wrongdoing. But by disclosing that data, it's going to obviously disclose some very potentially private, harmful things about, those patients that are in the hospital. So we have to think about how we weigh all those risks up in the law. In some countries and in many public sector organizations, public servants who disclose official documents to the media could breach official secrecy laws or national security laws as well. So we've got to think about whether we are going to permit those under the whistleblower protection law and how we might permit those. Do we need to actually amend and change all of these existing laws and legal provisions so that we can facilitate these disclosures? Are we going to restrict those disclosures to only a very, very particular set of circumstances? Or should we allow them in all circumstances? It's very much up to the countries, but I would say it's likely that those types of disclosures are only going to be allowed in a very, very small amount of circumstances. For example, if there's a real risk to the public interest. All countries adopting whistleblower protection measures should therefore conduct a review of the potential impact on existing legal provisions. And in particular, countries should consider the freedom of expression rights of all citizens, which are often contained in the constitutions of various countries. And countries also need to review whether they have adequate laws in place to protect journalists and their sources. Organizations are likely to encounter media scrutiny and possibly reputational damage if people make reports to the media. And this may prompt them to retaliate against the whistleblower if that person's identity is known. And it's important that if the whistleblower's identity is revealed, that there will be strong protections available to prevent any retaliation that could occur. Now, that retaliation could take many forms, and I will discuss that in more detail in the next webinar with you. But it's important just that we are aware of these things now. And, you know, in some countries, it could be that the organization tries to sue the whistleblower for something like defamation by alleging that the information disclosed isn't true. So how should the law deal with that? What processes and procedures should be in place to ensure that the whistleblower is not retaliated against if they have raised a genuine concern? Countries also need to consider whether to allow whistleblowers to go straight to the media with their reports, or whether they should first exhaust all other avenues first. So, you know, have they raised their concern internally or externally to an agency before they've then gone to the media? Now, this is, of course, very much a question for individual countries. And it's not for me to say what the best approach is, because there are many, many different ways of doing this. But although countries, some countries do allow disclosures direct to the media, and this is actually now becoming increasingly seen as good practice, many of these countries will still attach legal conditions to this. So, for example, a direct report to the media could be permitted where there is an imminent risk to the public interest, where there is a risk that an agency could collude with a wrongdoer, so could collude with someone in an organization who is accused of wrongdoing, or that there is a serious risk of retaliation. I think the key takeaway message that I would say is so important is to work out all of these points of best practice, but then to work out how to integrate those points of best practice in the context of the country in which you are based. Because different cultures have different needs. Different organizational cultures require slightly different responses. So we need to have an overarching whistleblower protection law and an overarching whistleblower protection scheme, but we also need to make sure that it's capable of being implemented in practice in the country where we're based. So I will now conclude the webinar for now, and I look forward to presenting the next webinar to you. Thank you for listening.